Well, you know what that graphic means. We bring in our legal panel now, as you do every Wednesday. Jim Kasuris, criminal defense attorney in Manhattan, sits on the board of directors of the New York City Criminal Bar Association, frequently lecturing at New York Law School and the bar associations in Queens, as well as New York City, as well as being a visiting professor at the University of Birmingham in England. Doug Van Oys, founding partner of Carson Van Oys, focusing on corporate misconduct, and was selected by the Legal 500 as one of the most influential trial lawyers in the nation. Mayo Bartlett joining us, attorney at the law offices of Mayo Bartlett PLLC and former chief of the Bias Crimes Unit at the Westchester County DA's office. And Mark Furnish, he joining us as well, Brooklyn law professor, recognized as a super lawyer. Mark has argued before the U.S. Supreme Court and was recently named Criminal Lawyer of 2014 by the Institute of Jewish Humanities. And guys, each of your backgrounds, I got specific cases I'd love to pick your brains on. We're going to get to that. But there was two big, a case before the High Court today, and also important news coming out of the Justice Department that's going to start this segment. And let's go to the Supreme Court, where for a second time, Obamacare, President Obama's signature health care bill, it is being tested in front of the High Court. Justices working to determine whether the law makes those in all 50 states eligible for federal tax subsidies or just people living in states that created marketplaces. The decision could affect affordable health insurance for millions and millions of Americans. President Obama's health care law was back in front of the Supreme Court. The Affordable Care Act, signed into law in 2010, says the federal government can give subsidies to help millions of Americans afford coverage that's bought through, quote, an exchange established by the state. And that's the simple phrase in a 1,000-page law that's at the heart of today's arguments. The plaintiffs in the case are conservative activists.
This was not inartful language. They intentionally set this up to try to get the states to set these exchanges up.
But 34 states didn't set one up. Instead, they rely on the federal marketplace. So the question now is, are the federal subsidies illegal in more than 2/3 of the country?
The government says Congress obviously wouldn't have doomed to failure this hugely significant piece of legislation.
The implications of this decision could be far-reaching. One study found that 9 million people could lose their insurance coverage if the court rules against subsidies.
This is about real people. This is about putting patients over politics. Don't take my care.
HHS Secretary Sylvia Burwell acknowledged last week the administration does not have a backup plan if the subsidies are struck down.
We don't have an administrative action that we believe can undo the damage.
Now, this isn't some theoretical debate here. The justice is expected to come down to a decision sometime before July here. And Mark, to me, and you've obviously appeared before the Supreme Court, this is about subsidies. And then this is also, I think, about justices, and really two in particular here. We're talking about Kennedy and Roberts, right? How much do they mitigate this with the textual part, and also if they do this and there's no remedy, the harm that could be caused?
Well, there is a remedy because Congress, if it's so advised, will fix it, and that's how our system should work.
Have you been watching your Congress lately?
Yeah, well, that was what was said in the argument today by Verrilli, and it drew a lot of guffaws. But you know, this is really, I think, the most legally substantial challenge to the statute that has been brought, because it's clearly, as you indicated, an issue of textual interpretation, and the government's interpretation of the statute flatly contradicts that which is contained in the text. So if we were just...
How important is it, though, Mark? Nobody's arguing, I think, that when they drew this thing up, they voted on everything else, there was never a scheme or an intent to benefit blue states over red states. So, yes, there's a language issue, I grant you, Mark, but how much does intent matter in this? Because there was never a scheme.
Well, first of all, that's not at all a clear point. There's legislative history that indicates, and we discussed this previously on the show, that this was a deliberate choice that Congress made in order to coerce states, or at least induce them, to buy into the scheme and establish their own exchanges. In other words, we'll give you the subsidies and you establish the exchanges. So it's not at all clear that this was just some sort of scrivener's error. This might
But they weren't forced to, and some states didn't.
Well, that's the point. If the court now upholds the plain text of the statute as controlling, it makes the argument that they have to buy in or buy or die, essentially, that much stronger. And then there's a significant coercion argument, and this was the argument that was did not carry the day in the first healthcare case, and will be given a lot more strength now if the text is read as written, to mean only if you establish your own exchange do you get the subsidies. That's the feds effectively telling the states what to do, and that's anathema to the Federalists.
Now, let's say that there's a compelling argument made, at least in the eyes of Chief Justice Roberts or Kennedy, and they swing over and it's 5-4 to repeal the thing.
Well, I'm not so sure that's going to happen. I think you could
Well,
see
I've heard different options that if it did happen, Mark, that if they think it's illegal what they did, do they have to right away say, you guys got 3 weeks to do something different? Some say they can't wait till the end of the year and put some stay or whatever. If it's illegal, it's illegal. You're not going to let the thing stay for another 6 months. What happens?
Well, you know, I didn't read the argument transcript today, but there's the issue of whether one part of the statute could be severed out from the rest of the statute, and I don't know how that came out today. They could find that this language is problematic, but say the whole thing still passes constitutional muster, and some sort of interim fix could be enacted either administratively through the APA, the Administrative Procedures Act, or by Congress. So I don't know what the practical consequences are going to be, but in this case, although on the law, I think the challengers clearly should win, I'm not so sure that they are going to win, because I think Kennedy is going to vote to uphold the act, and I'm not sure what Roberts is going to do.
I'm sure you follow what happened coming out of the Justice Department today, and this wasn't just everybody an expected ruling. There was some details that came out with data and also some of the emails that made more than a few folks do a double take. A scathing report from the Justice Department as it relates to Ferguson. The feds charging that Missouri town and that police department specifically within it had a series of civil rights violations, and they were all against African Americans. After the death of Michael Brown, protesters alleged a systemic police bias against African Americans. Now, an exhaustive federal investigation agrees, concluding that Ferguson Police and the local court system needs a major overhaul.
People feel under assault and under siege by those who are charged to serve and to protect them.
The over 80-page Justice Department report found a disturbing pattern of stops without reasonable suspicion, arrests without probable cause, and using unreasonable force. There were 161 complaints of excessive force between 2010 and 2014. Not one officer was disciplined. The federal investigation also uncovered 7 dramatically racist emails, including several targeting the president and first lady. A city official wrote in 2008, Obama would not be in office very long because, quote, what black man holds a steady job for 4 years?
It makes you say, they've been laughing at this community, they've been laughing at the people in this community for a very long time.
The reporters renewed calls for Police Chief Thomas Jackson to step down. Also announced no federal civil rights charges against Officer Darren Wilson. Now, the Brown family also said that they're happy the Department of Justice is holding the Ferguson Police Department accountable for the racial bias. They said that if it creates change, then the son's death will not be in vain. Now, Mail, for folks who are new to the program, they don't know, in addition to being involved in cases and representing us in high-profile civil rights cases, prior to that, you were in the Bias Crimes Unit in the West District Attorney's Office. Eric Holder also said something else before the report came out. It's too hard for the feds. At the end of the day, we saw what happened here in this case and whether people thought it was a right or wrong decision. The Justice Department, it's kind of limited what they can do, isn't it?
Absolutely. The Justice Department basically comes in and they try to clean up cases where it appears that justice was not served or fully explored in the state or local cases. But what happens is their resources have been gutted. They've been limited severely. The Civil Rights Division was severely diminished under George W. Bush. But in addition to all of that, they have a different burden. So where the states can charge you with assault, they can charge you with homicide, they can charge you with a number. They just have a tremendous gamut of different options. The feds are required to show that you violated a constitutional right, and that you intended to do so, and that you selected a person based upon some protected category.
But in this case, Mayo, they showed the population, let's say 2/3 black in Ferguson. yet they comprise 95% of the jaywalking stops. They comprise more than 90% of the traffic stops. They comprise 90% of all the stop and frisk. I can keep going down the line. There wasn't an equal application of justice, and you got cops, you've got city officials all on record saying horrifically racist stuff, not just about the president and the first lady, but about the people they're supposed to represent. What's the threshold for the feds to say time out here, okay? Maybe we can't retry the case of the Michael, but we can at least say there needs to be a monitor in place.
Absolutely.
Couldn't they do more than they are now?
Well, there's a federal monitor that you can put in place clearly. The city of Yonkers has had a federal monitor. And when you really stop to look at it, if you were to scrutinize every police department in the United States, you'd find that what they came up with in Ferguson is not an aberration. You can look at Pelham Manor, and you have racist emails coming out of Pelham Manor just the other day. You can look at stop and frisk in New York City, which essentially is not much different than what the Department of Justice found Ferguson was doing. And really a lot of this comes down to who your candidates are, who are you hiring, not training, but who is the individual that's a candidate to be a police officer to begin with.
So you weren't surprised, given your background at all, what came out of the report?
Not at all, but what I would say, though, again, is that if you look at all of these things, you have significant problems in police departments across the board, and it's an application of the law that is profit motivated. So you have officers who have quotas. You have officers who are told go out and make more arrests, write more tickets. When you do that, you're automatically going to alienate whatever community you're basically policing.
All right. We'll jump to break. We come back, guys, on this side of the table. Case in Jersey, if you've been following it here, where state lawmakers are livid and they're willing to take the case here to court here. They're attempting to block Governor Christie's Exxon settlement here. Will their claims hold up in court? Doug's going to explain how the math works here for these settlements and whether or not it's that uncommon, the deal that Governor Christie struck. We'll get into that. And also, I got a case, if you guys have been following what happened with Kurt Schilling, and I asked Jimmy if maybe there's a dawn of a new day as to where the limits of free speech start and stop, even if you do it from the basement of your home. We'll get into that as well.